Hello everyone, this is Professor Christiana Pruden here with another business law lecture. This week we're talking about agency law. And agency law is an area of the law which you are potentially entangled with without even knowing it. If you are employed or an employer or in a field especially like real estate or other areas like law, you are potentially in an agency relationship. You are an agent, a principal, or some party to this type of law, which we're going to talk a little bit more about. So what is agency? How do you get into an agency relationship? Like many areas of law, agency has elements. There are 5 elements that we talk about, my colleagues and I, that you need to make up an agency relationship. First of all, you have to have a principal. A principal, not to be confused with a principal, like the principles that you live your life by, but a principal is someone who is directing the agency, the person who's in control. Okay, someone who is giving consent, who is giving directions, who is in control of the agency relationship. Of course, then you have to have an agent, the person to whom they are giving directions and who is carrying out the orders of the principal. So first, 2 parties, principal and agent. Okay, and this can look like a lot of different relationships. It is not necessarily a contractual relationship. It is not necessarily a relationship where money changes hands. It is not necessarily a written, formal, compensated situation. It can be any setup where we have a principal, an agent, where we have consent is the 3rd element. So the principal is asking and the agent is agreeing to do something, to carry out some order. The scope of the agreement can be very broad. It can be do all sorts of bidding for me, be my agent, as it were, in a lot of entertainment purposes, be my personal assistant and do all kinds of things for me, or it can be very specific. Sell my house, okay, for like a real estate agent. But there is consent being given by the principal. The principal is asking the agent to do something, and the agent is accepting that task, saying, yes, I will do this. There has to be control by the principal. That's the 4th element. The principal has to be in control of the situation, giving the direction, and really guiding the relationship. Finally, the 5th element is that we have to have a fiduciary relationship. I don't know that we've specifically talked about the term fiduciary in our lectures yet. We may have. It's been a lot of talking, and yet not enough, right? Never enough. But the term fiduciary means a relationship of special trust. Okay? It means that if you are entering into a fiduciary relationship, you are entering into a relationship with someone where you have special trust, but also they are acting on your behalf. They are putting your needs before theirs for the purposes of this relationship. It is above and beyond just, your everyday dealing. It is a very special relationship in the law where if someone violates their fiduciary duty, if you have a fiduciary relationship with someone, like you do in an agency, and you violate that trust, then you are looked down upon in the law because it is a very close relationship. It is an important relationship. It's critical that there be that trust in that and that component there. So the fiduciary element really just has to do with a special closeness, not like, obviously not romantic or familial necessarily, but a trust-based relationship that has a special treatment in the law. So 5 elements: principal, agent, consent, control by the principal, and a fiduciary relationship. You have those 5 things, and you have an agency. Okay, nice little recipe there. But what about, what is it? Why does it matter? What does it look like? How is it relevant? As I alluded to on some level, a lot of people in this course and a lot of people in the world are in agency relationships that take the form of an employer-employee relationship. And we'll talk more about that in a second. But first of all, the important part really has to do with liability. Okay, who is liable? The principal has substantial liability for the actions of the agent. The agent still has some liability, of course, for what the agent does, especially, in their life. But in the scope of the agency relationship, the principal has substantial liability for what the agent is doing. So there are special duties that the agent has to uphold in the course of the agency relationship. The agent has to act in a certain way in order to fulfill their duties as an agent. The number one duty of an agent that, if breached, if broken, completely destroys the agency and is just a gigantic violation of the fiduciary element, is the duty of loyalty. Okay? The agent has to act in the principal's, for the benefit of the principal. The agent has to be loyal to the principal and act in their benefit at all times. There are a few different elements to this. So the agent cannot accept outside benefits without knowledge and consent from the principal. So let's say the agency relationship is one of an employer-employee, and it is the case often, not in like a restaurant scenario, obviously, but in other scenarios where certain employees are not allowed to accept tips, because in a lot of, let's say a plumber, okay? A plumber is hired by a company to do business for that company, and is paid very well by his employer. He is not allowed to accept tips from customers. The employer finds it important that the plumber maintain loyalty to the employer, who's the principal in this scenario. The employee is the agent, acting on behalf of the principal, and is not allowed to accept outside benefits from other people. That is the setup in some businesses. Like I said, in others, tipping is customary, but in some businesses, certain trades and things like that, the employer or the principal does not want the loyalty of the employee or the agent to possibly stray based on receiving extra little benefits here and there. Okay. Another way that an agent might violate their duty of loyalty is by competing with the principal. And in the employment context, we call this moonlighting. So if you were working for a mechanic, if you were a mechanic and you were working for a body shop, oftentimes they would have you sign something in your contract that said you could not moonlight, or you cannot, after hours, work on other people's cars for money, or open up your own little shop in your garage and compete directly with the body shop in the exact type of work they do. Basically take work out of their shop to your own little shop in your garage. Sometimes they don't care, but that's what moonlighting is. And as the agent, you cannot directly compete with the principal. You also cannot violate or release confidential information that you were made privy to while in your position as agent. So if you discovered information while employed by someone or while an agent, it's important the important part about this is that even if the agency relationship is terminated, we'll talk about termination and how these relationships might end. But even after the relationship ends, it is still the duty of the agent to maintain, keep secret, not reveal confidential information of the principal, which just kind of makes sense. You don't reveal the secrets of someone who is supposed to trust you with utmost respect. Also, you cannot, as an agent, have a conflict between principals. So agents can serve more than one principal. Think about a real estate agent. They're often trying to sell multiple houses. Or an attorney is often working for more than one client as an agent to a principal being the client. But you cannot have a conflict between your principals which violates your duty to serve them. So for example, if you are a real estate agent and you have two different clients who are both trying to sell their house in the same market, you can't play them against each other to try to maximize or minimize values. An example that's probably will make more sense because it's closer to my expertise is if you're an attorney, you can't represent two clients that may potentially have a conflict. If you are representing one party in a divorce, you aren't supposed to represent the other party because those are potentially conflicting people. Now, if the two principals agree and waive their potential conflict, then an agent may be able to serve principals that might have a conflict. But generally, an agent must avoid conflicts between principals. Okay? An agent, so the duty of loyalty is the biggest one. An agent also has a duty to not have secret dealings with the principal. Okay? This is still under loyalty. Not have secret dealings. So this is one that comes up in real estate. Not have a straw man transaction. So if, let's say, the agent is the real estate agent, and they are trying to broker the purchase of a house for a person, but secretly the real estate agent really wants the house. Okay, so they set up a straw man transaction where they pretend that there's another buyer for the house, that's someone else, but it's really them. So secretly they're really competing with their principal. Okay, they're secretly dealing with the principal in an icky. I have a 5. He's 6 now. Never mind. But sometimes those words still come out. Those 6-year-old words in a really harmful, distrustful way. Dealing with the principal secretly, not acceptable. Lastly, when it comes to loyalty, inappropriate behavior. An agent has a duty to act appropriately. So, for example, as an agent of Fort Hays State University, I have a duty to act appropriately in my position. It would not be appropriate for me to start making a bunch of wild videos and upload them here about conspiracy theories, or to go down to the local bar and go crazy. There are limitations on what is appropriate in your position as an agent, and you have to follow that. Otherwise, you're being disloyal to your principal. Okay? Other duties of the agent. Duty to obey. If the principal gives the agent a lawful command, then the agent must follow it. We say lawful because if the principal gave the agent an unlawful command or told the agent to do something that was against the law, then the agent would not have to do that. For example, if a client told an attorney to hide evidence or lie to the judge or something like that, no, the attorney doesn't have to do that. But a client has a right to steer the case and be in charge of their own case, and the attorney, as the agent for the principal, has to follow those lawful commands. That's the duty to obey. An agent also has a duty of due care, or to exercise the level of care that they signed up for or were hired for, the level of care that a reasonable agent in that position would exercise. So if that level of care is for an attorney, then that's what a reasonable attorney in that position would exercise. But if the agency, we haven't really talked about non-compensated agencies, but let's just say your neighbor is a nice guy and you ask him to help you sell your bike online, something like that. Okay, he's not getting any money for that, he's just a nice guy. What would a reasonable person in that situation do? Okay, probably not. That behavior or tenacity in selling the bike wouldn't rise to the level of what a compensated real estate agent would do trying to sell a multi-million-dollar house. Okay, it's what a reasonable person, reasonable agent would do in that situation. Remember, an agent doesn't have to be compensated. It doesn't have to be a contractual situation. It doesn't have to be formal. It just often is, because it makes it easier for the parties involved. An agent also has a duty to provide information to the principal and account. So provide information. An agent has to tell the principal everything the principal should know about the situation. It's not as if an agent has to sit down every night and talk to the principal for 5 hours about every single thing they did that day, starting with breakfast and ending with tucking into bed. But they have to tell the principal everything pertinent to the agency relationship that the principal should know. They cannot withhold important information. And they have to account, meaning they have to write down, keep track of. We're in the digital age, they don't have to write it down with pen and paper. They have to keep track of their expenses, their costs. If they're getting reimbursed for things, they just have to keep track of all that. Account funds in their possession, what they spend, what they earn, etc. And they have a duty to turn that over to the principal when needed. If the agent happens to not fulfill any of these duties, the principal has a few different remedies that they can pursue. They can pursue any damages that occurred. So if the principal hired an agent to sell their house and the agent breached their duty of due care, did not try to sell the house as well as they should have, and it can be proven that a reasonable agent in that position could have sold it on X date for X amount, then the principal may be able to recoup the difference in the money of what. Now they're still going to have to try to sell the house. It'll be a mitigation situation, so they'll have to try to get something out of it, but they will be able to recoup some damages if they lost anything out of the situation. They'll also be able to get back any profits that the agent might have inappropriately earned. So if the agent was competing on the side, moonlighting, the principal may be able to get those profits given to them. And they may be able to rescind any transactions that the agent entered into on behalf of the principal. So if the agent is doing business on behalf of the principal as an employee, entering into contracts, signing things, but is being disloyal, not acting reasonably, then the principal may be able to rescind those deals and those contracts. So, what does the principal have to do? A couple of things. The principal basically has to, what we call, indemnify. It's a duty to indemnify, which basically means reimburse. Has to compensate if that's part of the deal, and also has to give back for expenses and anything that the agent has put out for. Expenses, gas, printing, transportation. Okay. Also any losses to a third party. So if an agent has had a loss to a third party, which we're going to talk about in a second, like a potential tort, if an agent happens to neglectfully run someone over in their car while in the scope of their employment, it may be the case that an employer has to be responsible to the person that was hit. Not necessarily has to indemnify the person themselves, but they may have to pay the third party. We'll talk more about that in a second. The duties of the principal. So first, indemnify, just meaning pay. Pay the person for what they're doing, pay their expenses, and maybe pay a third party. And then cooperate. Cooperate is a big one of the two, really. They have to, if we're talking about, let's say a real estate contract, that's how I like to think about this one. If we have a duty to cooperate with a real estate contract, the principal cannot, the person trying to sell their house, cannot disallow the real estate agent access to the house to show it. Okay, that would not be cooperating. They can't go behind the agent's back and try to undercut them and sell it out from under them. That would not be cooperating. Sell it for a lower percentage. Okay, these things are all things that happen sometimes, but would be disallowed in the principal-agent relationship, in the agency context. A principal must cooperate with the agent in what they've instructed them to do. Okay, so they must indemnify, they must cooperate. We talked a little bit about how you set up an agency relationship. You give consent, you give control, you have a principal and an agent. In a fiduciary relationship, you have an agency. There also has to be some type of authority. Okay? The principal gives the authority to the agent in one of two ways, which really is broken down into three ways. There's actual authority, and then there's apparent authority. Actual authority is authority that is actually given from the principal to the agent. It is, and why I say it's either two or three, actual authority is either expressed or implied. Okay? It's either expressly stated, saying, I give you authority to do X, Y, Z. I allow you to sell my house. I want you to sell my house within 90 days for X percentage, all laid out in a document. That's express, actual authority given from the principal to the agent. Implied actual authority is that which is obviously implied in the directive. So in saying, I give you actual express authority to sell my house, it's implied that you are allowed to come into the house and show it to other people. That's implied in our relationship. It's how people sell houses, okay? Or in a trying to think of another good example. In an attorney-client relationship, if someone hires me to do a divorce, okay, they're hiring me to represent them in a divorce, it is implied that I am given permission to show up with them to a court of law, something like that, to speak for them in court. Okay, things that just go along, even though it might not explicitly state it in a document if we did that, or they might not have said it to me to my face. It is underlying, understood in what we're doing. Okay, but that all falls under actual authority. Apparent authority is what a third party believes an agent has depending on the principal's conduct. The principal's conduct causes a third party to reasonably believe the agent is authorized. Okay? The example I like to use for apparent authority is if a bidder from a big art house, okay, a big named art house goes to Christie's, okay, and they all know who she is. She's from this art house, and she's bidding on a tapestry, a really expensive tapestry. And they all think, okay, this makes total sense. We know why she's here. We know where she's from. But she happens to be bidding on the wrong one. Okay, so she doesn't have express authority from her principal to buy that tapestry, nor does she have implied authority. But she does likely have apparent authority from the principal as the agent to purchase that tapestry, meaning the third party believes that she is ordered, able, purposefully buying it. So once she purchases that $100,000 tapestry, obviously she can't pay for it. She's just the agent. The principal is still going to be liable to pay for it because she had apparent authority. Okay, even though she wasn't told to do it, it wasn't implied in her job that she would do it. It was basically a mistake. Okay, it depends on the perception of the third party. If it was reasonable for the third party to perceive that that was a rightful action of the agent that would have been authorized by the principal, then the agent likely has apparent authority. So the principal really has to be careful about things like that. If someone actually did that, the principal would probably want to terminate the principal-agent relationship. That's a pretty big mistake. How does a principal or an agent terminate this kind of relationship? Well, it can be a term agreement. It can be an agreement that they set up to expire either after a certain time or after the achievement of a certain purpose. Okay, so it can be a term agreement that expires after a time. It can be something that expires after they sell a house or finish a case. It can be something that can end by mutual agreement. So if both parties say, yeah, we're done here, no problem. It's also something that can end if one of the parties can no longer perform their duty. If either party lost a license that would disallow them, and I'm typically talking about the agent here, but that would disallow them to perform their duties under the agency. So a real estate agent, a lawyer, if they lost their license, that terminates the agency. If either party has a bankruptcy that actually impacts the agency relationship, that will terminate the agency. If there is a death or incapacity of either party, that terminates the agency relationship. And, as I said before, if the agent violates the duty of loyalty, that terminates the agency relationship. So those are ways in which the principal, or in some cases the agent, if something goes awry, or if they agree, if maybe things went well and they achieved their purpose, that's how it may end. Let's circle back for a second to a few special issues within agency. What about if we have an agent, okay, and we have a principal who doesn't want to be known? Why would a principal potentially not want to be known? Well, there's really one main reason, one big reason. That's because there are certain well-known people that are sometimes expected to pay more money for things than if they were unknown. The big example I'm thinking of is, or one way in which this happened, which might make it more clear than my vagaries, was when Walt Disney was buying up the property for Disney World in Florida. Walt Disney did that, and now that I'm saying it, not totally sure if he did it as a partially disclosed or an undisclosed, but we'll talk about that. He didn't want people to know who he was because he didn't want to be upcharged for the land. He wanted to be charged as a normal person would. And there are reasons why principals may hire an agent to purchase land, usually, or other property on their behalf, okay, or to do any kind of business or transactions on their behalf. So we've kind of got three different levels when it comes to disclosing a principal. On the first level, okay, we've got a disclosed principal. That's where the third party can see the principal, is really in privity with the principal. Okay, Think about the disclosed principal as going to Wendy's or McDonald's. You know, although you are doing a deal, you're talking to the kid at the counter with the hat and the apron, okay, you know that's not who you're actually making a contract with. You know that you're actually buying a Baconator and a Frosty from Wendy's, okay? But that's a disclosed principal. You know that this is an agent. The principal, you know who the principal is, and that's who you're actually doing business with, okay? That's disclosed to you. A partially disclosed principal is when you know there's a principal, okay? And you know you're doing business with an agent, but you don't know who the principal is. The agent will say, I am doing business on behalf of an undisclosed principal. I would like to buy your land, on behalf of this person. The important why we need to know these distinctions are because in a disclosed principal situation, the third party, or you, going to Wendy's, you can only sue Wendy's, okay? You really can't sue the kid unless, intentional. If he punches you in the face, of course. But if you have an issue, if you find something disgusting in your food, okay, you're going to sue Wendy's, right? You're going to sue the principal. But in a partially disclosed principal situation, the third party can sue the agent and the principal if you, figure out who they are. When you figure out who they are, the agent is buying for the undisclosed principal, but you can sue both the agent and the principal. The third level of this, that was partially, I said undisclosed. First, we have a disclosed principal. Then we have a partially disclosed principal. You know there's a principal, but you don't know who they are. Third, we have an undisclosed principal. You do not even know that there's someone that you are secretly kind of dealing with. You think that the agent is actually the person you're doing business with, but in actuality, they're an agent for an undisclosed principal. Okay? You, as the third party in that situation, can sue the agent, and you can sue the principal if you ever find out who they are. Typically, you're going to sue the agent, and then the agent is going to sue the principal to indemnify them. Okay, but you can sue both. In an undisclosed principal situation, you have no idea that there is even a principal on the other side. That's sort of blind to you. They're like a ghost. Okay, you don't see them. In a partially disclosed, it's like they're wearing a costume. Okay, you don't know who they are. They got a mustache and the glasses. Okay, you know somebody's there, but you don't know who they are. In the disclosed, there's just a person there, and you're like, oh, cool. It's who's the Wendy's guy? Dave Thomas? It's Dave Thomas. He's not alive now, but he does did a lot of really neat things for I think he adopted his daughter and has a really cool foundation. Anyway, disclosed, partially disclosed, undisclosed. 3 levels of disclosure, and the differences are, of course, who you see as the third party, okay, and who you can sue, who you're going to sue. Because you can sue both the agent and the principal in an undisclosed, but you're often not going to know who the principal is in that situation. You're going to sue the agent, and they're going to sue or recover from the principal, okay? So, that talks a little bit about principal's liability. What about a principal's liability for torts? And what about this employment context I've been talking about? So, remember torts. What are torts? Civil wrongs, right? Intentional torts are those which are done with intent behind them. Assault, battery, trespass to chattel, trespass to land, intentional infliction of emotional distress, right? Intentional torts are not what I'm talking about here, nor are criminal acts, obviously. I'm talking about negligence, mostly. A principal, okay, is sometimes liable for the torts of an agent, An agent is always responsible for their own torts. And we're really talking here about the employer-employee context. Okay? We're really going to be talking about employment for the rest of this lecture. So, an agent or an employee is always responsible for their own torts. If you hit someone in the company car, you're responsible for that. But your employer is going to be responsible for it too if it was done within the scope of your employment. Okay, so there's a few things we have to think about there. First of all, it cannot have been done intentionally. It cannot be a criminal act. It cannot be something that is done by an independent contractor. Okay, this is probably a distinction that you've heard, especially if you've ever been involved in any kind of your own taxes obviously, but any kind of tax prep, if any of you are accounting people. So the distinction between employee and independent contractor, what is that? Well, an employee is someone who is more highly controlled by their employer, by the principal in this case. An independent contractor is someone who is a contractor and who's just hired to do a specific function. Okay, and for the purposes of this specific lecture, when we're talking about liability and control, an employee is highly controlled by the employer or the principal, and the principal is highly liable for the actions of an employee. Versus an independent contractor, there's very low control by the principal, okay, and very low liability. I made a little chart here that I'm going to hold up, and P just means principal. Okay, you can see that as the control by the principal goes up from independent contractor to employee, so does the liability. Okay, an independent contractor is not very highly controlled by the employer or the principal. Again, P just means principal. An employee is more highly controlled, but an employer is also more highly liable for their torts and actions and any liability that comes with that. So how do we tell the difference between an employee and an independent contractor? There are basically factors. Remember, a factors test is different than an elements test. A factors test just throws a bunch of stuff at us and lets us weigh it and say, okay, does this seem like this? Does it seem like it's going this way or this way? And lets the court make the decision. So the factors include, but are not limited to, does the person have a lot of supervision? If they do, they're more likely to be an employee. Does the person bring their own tools or use tools provided by the employer? If they use the employer's tools, they're more likely to be an employee. Are they a full-time worker? If they work full-time, they're more likely to be an employee. Are they on salary? If so, they're more likely to be an employee. Do they have their own designated workspace? There are numerous IRS designated and legally designated factors, mostly having to do with, does the job provide you your tools, or do you bring them? What kind of supervision do you have? Are you expected to prepare not statements, but prepare reports for the job, for your supervisor? If you're expected to prepare regular reports for your supervisor, you're more likely to be an employee. Okay, and someone who is an employee, if they commit an act, a tort, while in the scope of their employment, then the principal or the employer is likely going to be liable for that as well. Okay. Respondeat superior is the legal term, which just basically means let the employer answer for the wrongdoings of the employee. Let the big guy answer as well. So the distinction between employee and independent contractor is important, but also the distinction between what the scope of employment is versus a frolic. And frolic is a legal term, okay? So scope of employment is you doing your job. Okay, let's say you are a delivery driver for a local Mexican fast chain restaurant. And you deliver tacos all around town. So the scope of your employment is going to pick up tacos at the establishment, driving them to point A, point B, point C, maybe getting gas, stopping, going to the bathroom, going back to the establishment, picking up more tacos, driving to more places. Okay, that's what you do. That's the scope of your employment. There are tons of other jobs in the world, but let's say that's your job. A frolic is going outside of what your normal duties are. Is basically if you think about your job as going on a path, whether it's actually driving a path, or if your job is quality control on a factory floor, okay? A frolic is actually deviating from that and doing something else, okay? A frolic is not going to the bathroom or getting gas or eating your lunch in the lunchroom. A frolic is going, outside and being on your phone for 45 minutes. Or in the context of the delivery driver, a frolic would be driving to your girlfriend's house and hanging out there. Or going and seeing a movie, okay? It is deviating from your normal tasks. And if something were to happen on a frolic, if you were to do something wrong while frolicking, again, legal term, while on a frolic or not doing your job, then your employer is not going to be responsible for that. If you are within the scope of employment, if you are an employee who is within the scope of your employment and something happens, then your employer is likely going to be at least partially responsible for that tort. Okay? So, again, the critical parts there are just remembering sort of what the distinction is between employee, independent contractor, and the distinction between actually being on the job and frolicking. And just remembering, what is an agency? What does it look like to set it up? What are the elements? What are the duties of the agent and the principal? What do the different disclosure levels look like? How do we terminate one? Okay, just looking back to make sure I remind you of all the important things. And yeah, what are some other areas of agency that you can think of? Reach out with any questions that you have. I keep using real estate, law, little bit of celebrity, lot of employment. But this, like I said, this is a very relevant area of law, or should be for most. If you do things for people, you may be setting up an agency, and hopefully you're very generous and do that a lot. So again, questions, comments, let me know. I'm always available and ready to help. I will talk to you again soon. Thank you.